Attorney Ludka Zimovchek is partner and managing attorney at NPZ Law. Hi, Ludka, welcome.
Hi, Vijaya. Thank you for having me.
Great to have you. And Ludka, we just discussed with David the considerations for the spouse and children accompanying the primary beneficiary of an immigrant or a non-immigrant visa. So what are the options for children in H-4 or L-2 status who are aging out of the system, like maybe turning 21 years old?
That's a great question, and you are right. So child under immigration law is unmarried and has to be under 21. So it's not 18, it's 21. And, it's a very difficult situation, and it's very sensitive because it's about the kids. And oftentimes we do have clients here in H-1B status for many years. So the kids might have been very young when they arrived to the United States. And suddenly they're turning 21 and they're out of status. Pretty much, they have to figure out their own status. So the critical is to start planning early. So when they hit, for example, 20, when they're 20 years of age, it's important to start planning what's going to be the next step. Generally speaking, we see a lot of F1s. So pretty much all these kids are already in college in L2 status or H4, and it's important to start planning. With the F1, oftentimes school will push them to go to the consulate because it's the easiest for the university. Just go to the consulate and get the F1. But the consideration here needs to be made, was there a green card petition filed for parents? I'm sure these children, well, they're not really children. They may be 20 years old, been in the United States for a really long time.
Yes,
so
pretty much their entire life, yeah.
Exactly. So there's always worry that they may be refused, if they go to the embassy. So second option is filing change of status within the U.S. for F1. But again, we've seen in the past 2 years, this has been taking for over a year. There is a talk about premium processing, change of status to F1 to use premium processing for additional fee. But as it is now, it takes really long time. So the key here is to just start planning really early on. There is a situation when the green card application was filed, they still may be in the green card application. So even though they aged out of the non-immigrant status, they still may be, based on the CSPA, as David mentioned, Child Status Protection Act, they may be part of the green card case. And if, in fact, adjustment was already filed, they may have a work permit. So in some situations, they just stay, the L2 or H4 will expire, and they'll stay at school or wherever they may be with the work permit based on the pending green card. It's just said if there is no green card or they aged out of the green card case and there is no other option. So once they change, for example, to F1 status, parents obtain the green card. Oftentimes, parents then will file for the children, but this is F2B category. So this could take another 5-6 years for them to get the green card. And meanwhile, they have to maintain the legal status for the 5-6 years. So it's not an easy situation. And I think the main point here is start planning early. Don't wait until the child turns 21. Start maybe a year ahead, planning and thinking about options. I'm sure there are other options as well, but the most typical way is just going to F1 for the time being.
Absolutely. So you said it right here. If you fail to plan, you plan to fail, right? So that has to be the first step to it all. And with a reputation for legal excellence and responsive client service, the business and family immigration law firm of the NPC Law Group represents clients from throughout the US and around the world. Seek their advice today by logging on to vserve.com or call them at 201-670